I was at a friend's house and saw my likeness on a video game that his kid was playing. I initially thought it was pretty cool and was flattered, quite honestly. But then it was brought to my attention that they had paid for that video game and I didn't get any type of compensation or even permission to use my likeness on that video game.
It was his height, his race, his skill set, his jersey number, everything but his name.
He raised this question of how is it possible that years and years and years after I played that the NCAA can continue to earn revenue off of my names, images, and likeness and not even consult me on that.
He saw himself in this video game and he realized, this is very odd. Here's a video game that makes millions of dollars, in part because it does a good job of mimicking your favorite college sports stars. Nobody ever asked me, nobody ever paid me for it, because when I became an NCAA athlete, I signed away all my rights to my image and control. So Ed O'Bannon sued in order to regain the rights and compensation from that, and that morphed into a more general suit.
The NCAA's original purpose at the time of its founding was to respond to violence in football and to make the game safer and to protect the health and safety of athletes, primarily football players. Today, on the NCAA's website, there are 3 priorities that they list: academics, well-being, and fairness. And yet, when they get into court battles, they tend to argue that they actually don't have a duty to do that.
The case began with 2 sets of issues. One was an antitrust claim, that schools and the NCAA join hands in an anti-competitive conspiracy to limit the value of college athletes' name, image, and likeness to $0. The other prong of the case was an intellectual property prong, and specifically the right of publicity. The idea that all of us have a certain right, intrinsic right in our identity, whether it's our name, whether it's our likeness, whether it's our image, whether it's our voice, whether it's our uncommon expressions, things like that, that there's value in everything that makes us who we are. And the argument was that the NCAA has profited from individuals' values in ways that were unlawful.
The main focus initially was to spark conversation and really get people to talk about what we felt college basketball, the conversation that we felt that fans and administration should be having. And that is not only do you control your likeness as a college athlete, but do you get paid while you're in school, while bringing in millions and up to billions of dollars for these universities.
In O'Bannon, the argument was you're ultimately competing businesses, and a rule that sets at 0 the value of name, image, and likeness isn't compatible with any precedent. I mean, nowhere else in the US do we say we can use your name, image, and likeness and not pay you anything. The intellectual property issues were resolved in a settlement. The antitrust issues remained and went to trial, and Ed O'Bannon won the trial. This was the first major antitrust decision against the NCAA.
Ed O'Bannon has come to symbolize a more general set of legal questions about whether or not athletes should be paid both for their likeness and images, which is the core of his case, but also it is, even if it's not the heart of his case, it's come to symbolize the bigger question of whether or not athletes should be compensated for playing.
Colleges join hands through the NCAA, and through the NCAA they create rules that are, the colleges would argue, are designed to ensure that there's fairness, are designed to ensure that college athletes are amateurs and not professionals. But in doing so, they create rules that many would argue are anti-competitive.
One of the reasons college athletes can't even have jobs during the school year is because there were so many empty jobs that were being offered by boosters that we've had to put a stop on it. The fact that we can't control certain people from corrupting the system from the outside means that we have over-inclusive laws just to stop the system from becoming a free market. The core of the antitrust rules is that unlike Google versus Microsoft, if we want teams to be competitive, we have to allow them to collude and restrict their ability to just act as free market actors. So you get special protections because the very nature of the enterprise is such that you would be destroying it if you allowed the free market to take over.
This was the first major antitrust decision against the NCAA. The NCAA for years has felt confident that it can win under antitrust law. In this case, showed the NCAA, no, you lost.
The court actually said the NCAA doesn't have to pay athletes, they're not true employees, but ended up deciding that the individual leagues could expand their compensation for athletes to take into account certain things, most particularly the true costs of attending.
The lawsuit put pressure on the NCAA, and the NCAA, many would say because of the lawsuit, allowed colleges to give what's called the full cost of attendance. And the full cost of attendance is a figure that's determined by the federal government. It reflects cost of living and other aspects that for years colleges weren't able to give student athletes. Now they can.
We should stay focused on making sure that student athletes get an education. As we professionalize sports, it becomes more and more divorced from the academic project, right? That these young people are less and less like students. And my concern is those who bemoan the way in which college athletics exploits young people, in particular young men of color, asking for them to be paid is not to reverse that trend.
Athletic scholarships are not free. If you're working 60 hours a week in your sport, that is not a free education. For many, many years, the NCAA argued and continues to argue that college athletes are just like every other student on campus. And that's simply not true. They're not recruited in the same ways. They are not retained in the same ways. They may not be able to pursue the degree that they wanted to pursue as a result of that athletic scholarship.
Times have changed. The game has changed. The amount of money that is made has changed throughout the years. The only thing that hasn't changed is the fact that these athletes receive a portion of that. Some of them would like to see the athletes receive something other than just a scholarship.